My name is Allyson Duncan. I serve on the United States Court of Appeals for the Fourth Circuit. I'm here today to discuss the role of women in the judiciary and to focus in particular on the concept of implicit bias, what it is, how it affects women in the judiciary and in the legal profession as a whole, and what women can do to protect themselves from its impact. What is implicit bias? Implicit biases are our unconscious attitudes or stereotypes. We make thousands of decisions every day. Our brains would not be able to process the information needed to make these decisions without relying on implicit biases. Even though every person holds implicit biases, this doesn't mean that every individual is bigoted. It simply means that our brains are programmed to make generalizations so that we can make the decisions necessary to carry out our day-to-day activities. In fact, some implicit bias is necessary to survive. For example, if someone were to point a gun at you, you would immediately know that you were in danger even before you could consciously process that thought. That would be because our brains have learned to associate having a weapon pointed at us with harm. Sometimes, on the other hand, implicit biases can be positive. For example, I have a friend who is a partner in a law firm. When he selects the lawyers to work with him on a particular case, he prefers to choose women who have young children. He believes that they are better organized, that they prioritize more effectively, and they waste less time than their male counterparts. So implicit bias can be good. It can also be harmful, however, when it influences conscious decision-making and leads to discrimination, disparate treatment, and lack of opportunity for certain groups of people. In the realm of gender, implicit bias is often driven by stereotypes about the roles of women and men. For example, men may be seen as competitive, aggressive, or powerful, whereas women may be seen as compassionate, gentle, or cautious. These implicit biases can result in men being promoted at higher rates than women, even where both are equally qualified. Today, I would like to discuss how implicit gender bias affects women in the legal and judicial arenas. While women now outnumber men entering law school, they fall off at an alarming rate as they proceed toward leadership roles as attorneys and judges. Why is that? I want to focus initially on women in private practice and then look at women in the judiciary. And finally, I want to briefly discuss lessons or takeaways that we can draw from both examples. I will start with the legal profession. At 200 of the largest law firms in the United States, women make up 40%, that's almost half, of the associates at the entry level. But then the decline begins. Only 30% of the lowest level of partner and 19%, or less than a fifth, are at the highest level of partner, those being the ones who have an actual ownership interest in the firm and share in the distribution of its assets. The attrition rate of women of color in law firms is even more dramatic. There are far fewer at the associate level and almost none at the higher ranks. That decline is due in no small part to the fact that advancement in the legal profession is often based on subjective criteria that are particularly vulnerable to implicit bias. First, implicit biases can affect the type of work that associates are given and on the basis of which they are evaluated. According to a report by the National Association of Women Lawyers entitled Report of the 2017 National Association of Women Lawyers Survey on promotion and retention of women in law firms, partners are much more likely to assign work to associates who look like them in terms of gender and race, and to advocate for those associates within the firm. As a result, female associates at the start of their careers are less likely to receive high-quality assignments and mentorship than their male counterparts. This also presents a double problem for associates who are women of color. The absence of women of color at a higher level of the law firm therefore becomes a self-perpetuating problem. They are not available to mentor the young associates who look like them, and as a result, there are fewer associates who look like them in the pipeline. Just being aware of implicit bias is one way to help combat it. For example, the Wall Street Journal had an article in yesterday's version recounting the story of a man who is a partner in a venture capital firm. He took an online test that revealed that, at least in his mind, he associated men with work and women with home. Now, he was particularly surprised by these results because he had always thought of himself as someone who supports women in the workplace. So to verify what he learned from the test, he wrote a computer program to analyze his business network, and what he found was startling. He found that 80% of his social media networking contacts and 80% of the contacts in his address book were male. So engaging in self-reflection and analysis helped him to realize that his implicit biases were influencing his decisions about whom to connect with in the business world. Similarly, in the legal profession, greater awareness of implicit bias can help address its effect on the advancement of women in the practice of law. In addition to being aware of the insidiousness of implicit bias, there are structural changes in the workplace that can help. For example, many law firms in the United States offer part-time and flexible work schedules. These arrangements are typically intended to increase retention of women at law firms. The basic idea is that women who choose to have children will be more likely to continue to work at the firm if they are able to take a reduced workload to care for their children. While these options are typically offered on a gender-neutral basis to both men and women, research shows that most of the attorneys who participate in flexible work arrangements are women. Such arrangements can indeed be responsive to the needs of working parents, but they can also be a double-edged sword. They can reinforce implicit biases about women in the workplace and the extent to which women are regarded as being less involved and engaged in business than they are at home. Women who opt into a flexible work schedule can be viewed as prioritizing home and family over the needs of clients and coworkers. As a result, partners may believe that family commitments preclude these women from being fully available and committed to work, even when the woman's work product is not negatively impacted by their work schedule. As a result of this, women opting into flexible work schedules may be passed over for promotion or for important assignments because of preconceptions about their limited availability. Implicit biases that link women to the home can penalize women in the workplace even when they take advantage of opportunities intended to benefit them. Although such stereotypes certainly present a problem, just being aware of the unspoken tendency to primarily associate women with duties in the home can help serve as a counterbalance to that kind of bias. Now I would like to turn to interactions between judges and counsel and talk briefly about women in the judiciary. Although federal judges and state judges in the United States are chosen differently, women are underrepresented in both systems. I had the honor to clerk for Judge Julia Cooper Mack. In 1975, she was appointed to the District of Columbia Court of Appeals, and in that year, only 43 years ago, she was the first African-American woman and the 8th woman overall to be appointed to a state-level court of last resort. Today, 33% of all state court judges and 20% of all federal judges are women. There has been a great deal of research done on this topic recently, and I will be sharing a copy of my sources with you. But for now, I'm going to talk about several examples, 2 based on research and 1 anecdotal of how women can be treated with distinction and disparity in the courtroom. A recent study conducted by the National Association of Women Judges examined the relationship between implicit gender bias and judges. Participants took a test to measure whether they associated the role of a judge more closely with male names or female names. The results indicate that many people, both male and female, make a significant implicit association between male names and judges. Implicit gender bias often manifests itself in interactions between judges and counsel as well. One example is the rate at which female judges are interrupted while court is in session. Researchers recently found that the female justices of our United States Supreme Court, for example, are far more likely to be interrupted by male advocates than the female justices. Another example is the way in which counsel interact with female judges in the courtroom, and this is where I speak from personal experience. I have noticed that many female judges are called ma'am, which draws attention to the judge's gender and distracts from her position, while their male counterparts in the same proceeding are called judge or your honor. This has happened to me a number of times, and I always say calmly and politely, "Counsel, you can address me as ma'am only if you address my male counterparts as sir. Otherwise, I prefer you to refer to me by my judicial title." These examples highlight some of the implicit biases that underlie interactions with female judges and the way in which judges are addressed and spoken to in the courtroom, not just by counsel, but by courtroom staff as well. Implicit biases often cast women as passive and quiet. It is not unreasonable to assume that these biases play a role in a male advocate's unconscious decision to interrupt a woman judge while she is speaking. And an advocate's difficulty in referring to a female judge as your honor may indicate an implicit bias that associates the role of judges more closely with men than women. What can be done? What are the takeaways? What are the lessons we can learn from some of the data that has been presented to us in recent years? I believe that the keys to combating implicit bias against women in the legal and judicial professions are education and vigilance. The first step is to simply be aware that implicit bias exists. The issue with implicit biases is not that we have them, everyone does. Instead, the problem is that if we are not aware of our biases, we allow our interactions with others to be driven by stereotypes about them rather than reality. We should therefore constantly challenge our own assumptions and ask ourselves why we react to certain people or things in certain ways. We should also educate our colleagues and institutions about implicit bias and encourage them to be more aware of their own hidden biases and stereotypes. There are a number of organizations through which one can do this and can join with others in making sure that it gets done. One example is the International Association of Women Judges, which sponsors conferences and task forces on gender bias and equality in the judiciary around the world. The International Association of Women Judges was founded in 1991 and now has 6,000 judges around the world. I had the opportunity to meet Vanessa Ruiz, its president, at the annual meeting of the International Association of Judges in Morocco in October, where she made a compelling presentation on issues affecting women judges. The International Association of Women Judges has an excellent website with information on how to join, and I commend it to you if you are not aware of it. I said that education was one key to addressing the problems of implicit bias, and the other is vigilance. The process of addressing or confronting implicit biases is iterative. The more we engage with and focus on our implicit biases, the more we will discover how they influence our decision-making. We have to be aware of and constantly evaluate our unconscious biases and encourage our colleagues to do the same. And we need to interact with our female colleagues. We need to join organizations and make common cause on the issues. We need to nurture the pipeline of lawyers and judges who might become leaders in their professions. And we need, most of all, to continue to participate in conferences such as this. I appreciate the opportunity to share these thoughts with you today. Thank you.